years.
All right, we're back in Senate Judiciary. We have Judge Zone and Terry Curtis to talking about S12.
So good morning, Tom Zone, Chief Superior Judge. I'll start off and just talk about some areas of the statute that I think you can help with the bill to draw to your attention. I would note that right up front, there's a large number of provisions that are going to be moving forward that are currently in existence. It is not my desire or goal to sit here today and say, oh, let's go back and revisit what has been in law for several years. I may have noticed things and said, well, yeah, what about this? You might want to think about this, but generally they're policy decisions. And I'm not going to sit here today and highlight policy decisions that were done previously. The goal is to discuss some of the changes and the impacts of those changes. And I know Terry will discuss that also. That being said, if you have any questions about other matters that I don't bring up, certainly let me know and I'll address them. The first page I wanted to touch on was on page 6 of S12. If you go to line 16, it says a designated felony property offense. Line 16 identifies a felony violation of 9 VSA section 4043. There is no felony violation of 9043. Under section 9, under 9 VSA 9044 is a penalty provision. They're both misdemeanors. And so that is not correct. You have to change that.
So we should perhaps get rid of the pretend felony in the bill?
I think so,
Okay.
yeah. So that would have to come out.
I know our watchful web counsel is listening in, so.
If you go to page 16, on line 20 and 21, this talks about what is now going to happen for the ability to have things sealed. And it says at least 3 years have elapsed since the date on which the person completed the terms and conditions of the sentence. What has been changed from the prior language or the current language, if you will, is the word successfully. Because it does currently say successfully completed. The word successfully is no longer there. If you turn the page to page 17 and you look at lines 5 and 6, when a sealing is sought, the court has to look at the following. The respondent has failed to show that sealing would be contrary to the interests of justice. I point this out because successfully completed is one thing. If it doesn't have to be successfully completed and the court has to apply the interest of justice, you should understand that is not a concrete term. I can envision circumstances where two judges looking at the same fact will come up with different sides of the table. And for instance, you have an individual who is placed on probation. They successfully complete probation, and their case goes to be sealed. Well, the interest of justice, I think most of us would agree that they've done what they're supposed to do. So that looks like something that it would be sealed. You take a situation where someone has a violation of probation filed, or maybe 2 or 3 violations of probation filed, and they have sanctions imposed. But at some point, they do complete probation. They don't have the entire underlying sentence imposed, but they've had some sanctions as part of that. You present that to a judge, I can assure you that there are some judges who might say, I don't think the interests of justice are appropriate for someone who kept screwing up on probation and had to keep coming back to court. Where another judge could look at it and say, well, the end result was they didn't have the sentence revoked.
Am I understanding you that successful completion would convey to all judges a certain state of affairs, or is that another one subject to interpretation?
I think that it's a different type of interpretation, but I wanted to highlight the idea that the interest of justice, because that same question could arise there too. What does successful mean? Does it mean that you got there without having the entire sentence imposed, or areas within it? And so I just wanted to highlight that there are going to be circumstances that judges will not see things the same way.
No, under the current system of expungement that exists, yes, where the judge looks at it and gets to decide if it's going to be expunged or not.
If they successfully complete, yes.
But that same discretion is allowed, where a judge can take a look and be like, they got there, that's successful, versus another judge might say.
I think that's correct.
Okay. So it's not a substantive change over what we allow
I
current
think-
for discretion.
I don't think it's a substantive change, but if there's an expectation that the phrase interest of justice adds some type of concrete analysis or some type of concrete criteria, I just want to let you know that's not the way it is, but there still will be that discretionary balance that the court will have to wrestle with.
So my follow-up to that, and you may well say that it's a policy decision and you're not going to weigh in, and that's fine, but do you think it would make sense for us to clarify and define what that means some?
I think we can work with this.
Okay.
But I want to make sure the legislature understands, that this committee understands that it's not a term of a clear and unmistakable definition.
Now, would you be opposed if we decided we wanted to clarify what we meant some?
No.
Okay. So it's a policy decision.
It is a policy decision. Either way you go, we will be able to work with it.
Okay.
But again, we have sat at this, and I sat at this in this very room. And I remember Senator Sears saying, well, when we did this, we expected, or we thought. And so that stuck with me, that I want to make sure if I have any ideas that I think you might have expectations on, that I let you know how they may be realized or not realized. The next one I want to talk about and just mention is currently there is on page 26. We're now getting into those exceptions for the use of sealed records.
Yeah.
Line that's 19 through 21 and exception 6. It says the state's attorney and attorney general may disclose information contained in a sealed criminal history record when required to meet their otherwise legally required discovery obligations. My thought is that you might be able to say that a little bit less wordy. If you just say the state's attorney and attorney general shall, because disclosure of discovery is not optional, it's required. So the state's attorney and attorney general shall disclose information contained in a sealed criminal history record when required to meet a discovery obligation, period. If they have that obligation, I'm sure the state, earlier this morning, you probably heard phrases such as Gilio or Brady, things like that. This is part of that. And so it's not optional, it's required. And I think the word, it says may disclose.
Right.
That could make some think it is discretionary when it's not.
What was the other part, Judge?
It would just say to meet a discovery obligation at the end.
Because legally required.
If you're required, yeah, you're already legally required to.
Yeah.
Page, I hate to backtrack, but page 21, line 4. It says new charge. As a criminal charge pending at the time the petition for expungement is before the court, shouldn't that be sealed? If you're going to a system of sealing,
Where's this, Judge?
on page 21, line 4.
21.
Page 21, line 4. Has a criminal charge pending at the time for expungement, or maybe what you really want to say is expungement or sealing, because there are still provisions where you can get expungement, but you should add sealing in there.
I'm wondering if
Let's say
we're going to end up having a discussion as to what we're going to call this system eventually anyways, whether it's going to be expungement or sealing. I mean, it is whatever we refer to it as, but I know other states have a system similar to what we're proposing here, but they just call it expungement. But I mean, that's semantics for later on. But yes, please continue. You have a question?
Terry will talk about this more, I'm sure, but I did want to point out that throughout it talks about, if you go to page, for instance, 31, under the expungement for criminal records of individuals 18 to 21, that's current statute, but the court doesn't know when someone successfully completes their sentence necessarily. We don't get notice. That is an area that you're gonna.
Which line?
It's on lines 13 and 14. Yeah. I'll let Terry talk about that in greater note, but I had a note on that. I just wanted to highlight that we don't know if someone does it unless somebody tells us. And that's carried through in a few different sections around there. And then my last comment would be on page 36. And it's in the section for deferred sentence. Would it be helpful if I explained what a deferred sentence was?
Yes, be great.
Under Vermont law, the legislature has enacted a statute that allows a court to place someone on probation under terms of probation. There are certain convictions that the legislature has said someone cannot be placed on a deferred sentence for. But when you are on a deferred sentence, you are on probation. Prior to being placed on probation, you sign an agreement with the prosecutor, or the court orders it over the prosecutor's objection. And it says you will be on probation on this deferred sentence for X amount of time, let's say 3 years. You don't get off early. You don't petition for early discharge. It is a 3-year term that you've agreed to do that 3 years. And at the end of that 3 years, if you successfully complete it, the current statute says that your conviction is expunged, not sealed, but expunged. The effect of that certainly is as though it never existed. And as you know, the difference between sealing and expungement is those records aren't around to be looked at anymore. They're gone. If you don't successfully complete it and you violate it, you come before the court for sentencing. There's no agreement as to sentence. By engaging in that deferred sentence, in some ways, you're taking, as a defendant, you're taking a risk. You might have a case up front where the sentence could be something that you find acceptable. Yet, if you violate or do something while you're on that deferred sentence, when you come back before the court, that sentence is solely up to the judge. It's a much more severe sentence than you would have gotten earlier. And so it also may be deferred on a charge that the state was willing to dismiss if you would have taken a permanent conviction. So there's a real risk for individuals when they go on that. But it says if you complete it, your conviction is expunged. This change would say your conviction is sealed. That's a policy decision. But you should be aware, if you change that, you should consider that there will be challenges to whether or not you can change existing deferred sentences where there is an expungement agreement and the court imposed that as the sentence with the person knowing they were going to have it expunged, and then say, well, no, now it's only going to be sealed. There will be challenges, and that is something that I suspect the Supreme Court would have to address. There are the challenges that we would expect would be retroactivity and other things. I am not telling you an opinion on which way it would go or my thoughts on it, other than to say you should be aware that if you choose to say don't have exceptions for deferred sentences imposed on or after the effective date, then you will have challenges to ones that are currently in existence.
Right.
My quick question about that. Do you happen to know what the longest deferred sentences that could exist at the moment? Because what I'm thinking about is grandfathering in whatever the current deferred sentences are. So, just creating a different timeline for this particular section.
You could just add a subsection that says any notwithstanding subsection, whatever, any deferred sentence imposed prior to the effective date of this statute, defendant shall be subject to expungement. Anyone imposed on or after the date of the effective date shall be sealed and shall not be entitled to expungement. That would cover that.
Thank you. So,
This might be a better question for the state's attorneys, but is there any concern from your view that taking away the protection of expungement may make fewer people engage in that deferment process because the carrot has changed significantly?
I have thought about that, and I don't know. I don't have an answer to that, frankly. I think that's a good question for the defense bar,
Okay.
The defender general, as well as the state's attorneys. I can envision some people who might say, oh, expungement's better.
Mhm.
But if you look at the definition of expungement and you look at the definition of sealing, you get to the same end result.
Well, I think it depends who can see it.
Exactly. You get to the same end result for people to see. And then if you change things here, the question would be, okay, is that difference enough for someone to say, well, I don't like those exceptions?
Mhm.
Because today, you don't have those exceptions
Exactly.
like that. And so today, probably not going to make that much of a difference. If you have this, that there may be those who think it is an impact.
Okay. Thank you.
So that's all I had to comment this time.
Thank you.
I'm Terry Purcell, State Board Administrator, and I guess I'll follow up on what Judge Loney was referring to, that from what I understand had actually been testified to by Judge Harrison in the past when this was first proposed in terms of the expungement that takes place after a sentence has been completed. And that's on, as he said, on Judge Loney said on page 31. Just to remind the committee that the court doesn't have the ability to ascertain when a sentence has been completed. That's something that the Department of Corrections has jurisdiction over and tracks and all of that. And at the time, it's my understanding that Department of Corrections indicated they wouldn't be able to, for whatever reason, provide the information to the courts to track it that way. So in that particular category, we would be processing those only in the petition state of somebody's petitions to have anything place. So I just make mention of it just so you're aware that that's kind of the situation. We don't know once the sentence, it goes over to the Department of Corrections, it might be minimum, maximum, could get modified, you know, so it's not something that we have the ability to track. So I just wanted to kind of remind the committee of that. And the only other kind of question I had about the actual verbiage had to do with a term. This is on page 27. It has to do with the proposed access of a person or law enforcement to access. The way it's termed in the proposal is criminal history records. And it talks about the person having the 10-year limitation, and in law enforcement, I think it's forever. But the criminal history records isn't something that's within our public access to court records terminology, if you will. So our assumption is that the access to that information would be through BCIC. But we just wanted to kind of get clarification on that, or ask a clarification versus coming from the courts, because we don't typically provide criminal history records, at least according to that verbiage. When the public access to court records, for example, it refers to case records or court-generated records or judicial branch records. But the criminal history records would be an online war background check information, which would be through BCIC. So I just wanted to
Thank Perhaps I also need more clarity. I don't fully understand. Can you just run the issue by me one more time? I don't fully understand.
Okay.
Yeah.
So under the public access to court records statute, the court is required to provide, and the way it's termed, case records, court generated records, judicial branch records. This verbiage is criminal history records.
Okay.
So that's why we just wanted to make mention that.
Got it.
Gives that kind of question, or and we're assuming BCIC would be the person or that's meant to be providing access for those two provisions, but just wanted to make mention of that.
Senator Morris.
Yeah, Terry, in reference to the criminal records. The criminal records accompany the court casework that goes to court. So I would think that they can't provide the most recent, of course, the most recent up-to-date criminal records, but the record that was one with the court case a year ago is still with that court case. So that get old records, is what we're saying, right? Is the key we're trying to make here?
You mean if somebody went to the court?
Yeah.
I guess I'm just saying under the public access to court records statute,
Right.
those are the categories of records that we provide access to versus criminal history records, which isn't something that presently is
Thank you.
described that way. My only other, I guess, comment regarding the proposed bill, oftentimes, and we really appreciate it, you all ask what would be the impact on the courts if the proposed bill goes into effect. Since this is adding additional categories, for cases that can be sealed, if you will, there would be an impact, but I wouldn't be in a position to say, oh, gee, we're going to need X number of full-time employees to handle this increased workload. But I would just ask, for example, after if this is passed, after a year, we would be in a better position to say, oh, here's what the impact has been, if there is one. The other part of it is we had, and you may recall that, we had asked for 11 court security officers and, given those positions. The part of the job description for the new, court security officers is that if they do have time, if they're strictly, to be in courtrooms for hearing time, the court security officers, they're not law enforcement, they're not armed, but they're in the courtroom. If a case is continued or ends early and they don't, they're a lot of time then that they're not being utilized for courtroom proceeding. We had built into the job description that they would have court duties in terms of helping with case processing. And at the time, we didn't necessarily know what that would be, but it seems to us that working on expungement cases would be logical, because something we could pick up and put down more easily than some other kinds of case processing. So they're being trained for that right now. So in a year also, we'd be in a better position to know how much of the expungement work, which is tens of thousands of cases per year, they've been able to absorb, and again, to be able to indicate whether or not there's an impact or the need for additional court resources.
So my initial thought was, if we're shifting to a ceiling system, that it would significantly, hopefully, reduce the workload. But that's not the case.
No, the steps are very similar
Okay.
for a ceiling case versus expungement processing. There's multiple steps involved.
And everyone is touched by a staff member, signed by and reviewed and signed by a judge. So it just, the judge is going to review whether it will be an expungement or a sealing, and a staff member doesn't. So every one of these cases, when you hear under the state's attorneys talks about the impact on staffing and what they have to do. But just keep in mind that all begins with judicial assistants and judges reviewing and signing off on every single one of these.
We provided information, this was back in 2023, case processing steps to expunge or seal a case when orders receive that much. There's like 31 different steps. I mean, it's a process. And part of it too, doesn't even, we have to, for example, check to see if restitution has been satisfied. So part of it involves sending it for that verification and then waiting for that. It's kind of like, it's not necessarily we do it all in one sitting, but I did ask that specific question, and my understanding is that the steps are very similar.
And so I think, one thing to flag is also 7609, which is on page 31. This is for the committee, which still contains expungement for criminal history records for anyone between the ages of 18 to 21. And so the question that we'll have to discuss is, do we keep that, or does that also go into sealing? If the idea is to switch to a sealing system. So that's, I think, going to be a big question in the committee later on. I am curious how has this been enforced, or this section 7609, how has this been done over the last couple of years since enacted, if the court isn't getting information about when the sentence is concluded or completed?
I asked that question because, as you say, there's no mechanism for us to be notified when it happens. And basically, if a petition is submitted, that's when we would know that scenario is present.
Also, keep in mind that there is this, as Terry points out, first of all, there's subsection, where is it? It's subsection C that she points out about a petition being submitted. So the statute itself provides for petitions. So I think that's correct. But there's also an overlay to this in Title 33. 33 VSA section 5119 is a sealing statute on application of a person who has pleaded guilty to or been convicted of a commission of a crime under laws of the state of Vermont that the person committed prior to attaining 25 years of age. The court shall order the sealing of, if it finds that 2 years have elapsed since the final discharge and the person has not been convicted. So we do see a number of petitions under that too. So they essentially are just an overlay there. You would be entitled to ceiling under 5119 if you applied. You'd also be entitled to expungement for certain qualifying offenses under 7609.
If there's no questions, I'm gonna just spin my hat a little bit and just touch upon by the committee. On page 33, under 7610, I wanted you to just comment a little bit on that and give us some update on.
Let's see on the section.
Criminal history record ceiling special fund is.
You want to take that one?
I don't know, to be honest, I don't have the information. I don't know, I didn't realize there was a.
If you don't have the information, that's fine, but if something you could supply to Kayla, I would assume it'd be all right.
The only comment I'll make, I know Terry can certainly look into that. As a global matter, though, there's been a number of study committees that the legislature has enacted. One of them had to do with the Coordinated Justice Reform Advisory Council. That was how DOC would spend certain monies that it's saving on inmates going out of state by keeping more inmates in state. And that those monies are generally utilized for CJCs and reparative programs. The committee, which I have the pleasure of chairing, we did a report, and one of the things that came out of that report, Senator Sears was on the committee, and now Senator Hashimas. We recommended that the legislature look at not using these types of funding mechanisms, special funds to fund things. I'm on several other committees, and I know that those are the same types of approaches that people are taking there. In other words, what I think you're going to start hearing about special funds is that because there can't be any consistency or predictability for some of the special funds, that many of the groups that would be recipients of those funds are suggesting that they go to general funds, and the risk, if you will, of any changes be borne by the legislature. So
Yeah, I think most of the special fees you're talking about had to look more related to traffic fines and so on and so forth, but this appears to be derived directly from those applicants applying to seal their records, these funds. So that's why I was just curious as to what may or may not exist in that fund and who may or may not be using it.
but if there's, I think one of the things we're going to see, if this were enacted, there's going to be a number of areas that are going to be, a number of those cases, for instance, have to be sealed automatically within 60 days, irrespective of petitions. There's no fees coming in on those.
Well, if we don't address it, it'll probably get enacted, so let's see what's going on.
Yeah, so I think it's a good thing to highlight, because I think there could be some changes in the monies that are expected once the process that's more comprehensive like this goes into effect.
Why don't you do that $10 million or something?
And I see that it looks like to seal a criminal history record with a violation of 23-1201 to the driving under the influence, it's limited to those. But I will be happy to check and see what.
Thank you.
So there's a fee associated with getting the record sealed or expunged?
I was thinking that there wasn't, but I don't know that for a fact, so, but it sounds like there definitely is it's for driving under the influence. Let me see if I can ask that.
There are certain fees that for certain requests.
And is there any waiver for someone who can't afford the fee? I'm really concerned that access to justice should not be predicated on one's ability to pay.
And my experience is that yes, so there's always the opportunity if someone can't pay the filing fees, they have the opportunity to make an application
For waiver based on lack of income.
based on their particular financial circumstances.
Okay, is it possible to get a little bit more detail on what that means, what the thresholds are?
Yes.
Awesome, thank you.
Oh, it's the general fee waiver. For example, if anybody files any court petition, they want to waive the filing fee, for example, and sometimes you waive the service fee. So it's based on income, basically.
Right, I'm wondering what those thresholds are, and I just want to take a look at them in terms of 2024 realities. Are they what they should be?
Yeah, and it's adjusted annually based on the poverty guidelines.
Okay.
I do know that, but I can get you one of the forms that you can see exactly.
Thanks.
And I think it one, for example, automatic if you receive public benefits, I think that's eligibility. But I'll get you the actual, form so you can see that, and then also the amount in the fund.
No, I appreciate that. I know we live in a world right now where more than 50% of Vermonters can't afford an emergency $500 bill. So I imagine it's not 50% of Vermonters that are living at the federal poverty guidelines. So I just want to make sure that we're being responsive to the realities of 2025. I think I said 2024.
Okay, so I did get verification, because that was my understanding. She said there's a $90 fee for the DUI cases, and that was fee for the special fund. No other fees for expungements or sealing. Okay, that was my understanding, so.
There are certainly certain ones, and that actually, there were some changes, I thought, to that legislature last year, I think, or the year before. That was changed, I think, in the past few years for clarification, some questions about that.
Just a sheet that shows me, I'm fully aware it's 1201 now, $90. Where is it? Is there any, I just need something for
Right,
the other end of the holidays.
and I'll find out who originally sees that and let me know this.
Thank you.
Maybe any further testimony from you folks?
No, unless you have questions, and I will follow up.
Awesome. Thank you.
Your question about.
Maybe any general thoughts? Questions?
Not there yet.
Not there. Next up, we do have Charity Clark. Day lows at 11:15, so we'll either take a lengthy break or discuss what we've heard for a few minutes. I mean, we've gotten a lot of information in a short time, and there's nothing wrong with marinating on it for a little bit, but a conversation to start, we take a break until 11:15.
If we're gonna have a conversation, I'd rather at least Senator Bree be here so you can be part of that conversation. Still gonna have to rehash it.
Yeah. That's true. All right, well,